see so many of you here this afternoon. You're very welcome to this, what we hope, I think, that it'll be the first rather than the last seminar we do on the amendment to the proposal to amend the Constitution from a children's rights perspective. My name is Ursula Kilkelly, and I'm a lecturer here in the Law Department, and have, with my colleagues, been involved to an extent in the proposals and I suppose submitting our views to the Oireachtas Committee in this area. And the idea, I suppose, for the seminar came out of a conversation that I had with Emily Logan quite recently, and also general thoughts among my academic colleagues and myself about the importance of creating an awareness about the proposals, about the need for change and reform on a constitutional basis, and also the need for us to get involved in the debate around the amendment. And so myself and Conor decided to get the ball rolling, as it were, in that process, and to an extent to try to be ahead of the game in relation to what may come at us. As you will hear, we don't know yet the status of these proposals, but that doesn't stop us from raising awareness about them and debating their merits. So that is the purpose of this seminar, and again I'm delighted to see so many of you here, and I hope you'll participate fully in our discussions this afternoon. We have three speakers. We are very fortunate that we've been able to attract Emily Logan, the Ombudsman for Children, Conor, my colleague, who's going to talk from a constitutional perspective in particular, and Rosemary Horgan, who's a partner with Ronan Daly German solicitors, to give us a professional legal perspective, if you like, practitioner's perspective on these issues. The format is that each speaker will have about 20 to 25 minutes to present, and that should leave us lots of time for discussion. So without further ado, I'm going to invite Emily Logan to speak to you. Many of you will know Emily Logan as Ireland's first Ombudsman for Children. She's recently taken up her second term, that's the word, thank you, and has really established herself as an independent advocate and voice for the rights of children in Ireland. So I'm absolutely delighted that she's taken the opportunity to participate in the seminar, and I'd like to present her to you. Thank you.
Let me just get to this slides. Good afternoon, everybody. It's lovely to be here in Cork on such a gorgeous day. Thank you very much, Ursula and Conor, for the invitation. It's always a great privilege for me to get an opportunity to talk to people that I hope may be predisposed and share some of my thinking around children's rights. I have to say, having been in the post for 6 years, this is the area that I have found or have had most confrontation and most difficulty, in particularly not just at a public level, but certainly at a political level. That has been probably the most tension, and the most difficult meetings that I have had have centred around constitutional change, dating back to my first year of office in 2005. Just very briefly to explain the context in which I'll be speaking this morning, really what I've been asked to do is look at the need for reform. So what I'd like to do is talk a little bit about our experience in the office and match that with some of the advice that we've given on the past, centring on probably around the umbrella principles of the UN Convention on the Rights of the Child. But to give you some context, I should probably tell you that my office and myself, I suppose I'm a corporate soul in the sense of my accountability is directly to the houses of the Oireachtas. And yes, many of the commentary that I've had around the Constitution has, I suppose I would like to see that it has firmly placed the office in an independent, while sometimes an unpopular position politically, as an independent advocate for children. That's what the Oireachtas wanted. They wanted an independent voice, but sometimes that's not always. That's always what they get, but that's not always what they want when these kind of things become very difficult. Just to give you a sense of, we do look at independent cases. Let me just look at this end.
F5.
F5. Just to give you a sense of the work of the office and how that's growing, dating back to 2004 and the inception of the office, many people didn't know about the office, and the nature of the complaints that we were getting was quite different than the complaints that we've been getting more recently. In particular, I would say that there are certain triggers in the public consciousness and psyche around the work of our office. I would say the most significant change dated back to October 2005 with the publication of the Ferns report. And any time a report comes into the public domain, I don't have to release it into the public domain, but when there is conversation around child protection, that definitely, both politically and in the public consciousness, does something to remind people that we're there, despite the fact that we don't have statutory authority in that regard. So this just reflects, I suppose, the number. I'm not as interested in the number of complaints, but more the nature of the complaints that are coming to our office. The cumulative growth, I like to show because it looks a little bit more dramatic. But it does give you a sense that I suppose we're beginning to develop a body of evidence, and I suppose I'm speaking with a little bit more confidence than I spoke 5 years ago, because we are beginning to see patterns and we are beginning to see recurrence of themes from parents and from children. In terms of the complainants and the people who come to our office, I think it's important to emphasise that 78% of parents, children and extended family members, so 78% of the people who come to our office are family members. And I think that's important when you start getting into a debate about who represents or who exercises children's rights, and if there's a conflict between parental autonomy and the rights of children. Some people comment that the number of complaints coming directly from children is quite low at 4%. I would say that that's perfectly appropriate. Most of the children, in terms of complaints and investigations that are represented, tend to be children that are quite young, of primary school age, and children who do not have the capacity and who are completely reliant on an adult to represent for them. In terms of the nature of complaints, it's not any surprise that the big hitters are health and education, followed by justice, and then housing and planning. And that has been quite consistent. Health and education, just slight shift over the last 5 years in the office. But I was going to start really with the publication in February this year of that final report of the Oireachtas Committee on the Constitutional Amendment, because I think for me that is a most significant step. The first Oireachtas Committee I met was the Constitutional Review Group, and I was asked to demonstrate some live issues, in particular around child protection, because certainly in the context of political debates, it has been child protection that has been a significant trigger in terms of a response. You probably know that this debate dates back to 1993, when Justice Catherine McGuinness and her team referred to the requirement for a clearer and stronger articulation of children's rights in the Constitution. So this new proposed wording, and I say that with caution because people keep saying to me it hasn't been to the Attorney General's office, so be careful not to be so naive as call it the amendment, but a proposed wording. But what is significant is that this group have sat, they met on 64 occasions, you now have cross-party political consensus, and I do think that is a very positive and a very, very significant step. It's the first change for a very, very long time, and I'm also aware that changing the Constitution, of course, those fruits will never bear quickly, and the circumstances which prepare the way for a referendum are always subject to political alchemy. The triggers and the reasons why people change legislation, and in particular the reasons why members of that group have had struggles with constitutional change, have varied. So it hasn't been without its difficulties. As an Ombudsman for children, I would say in the last 6 years, I would see a change, particularly since the publication of the Ryan and Murphy reports more recently, in terms of the public acceptance or any, I suppose the obstacles that may have existed in the past aren't quite as trenchant as they may have been 5 or 6 years ago. And I think it's really important that we recognise the momentum, the growing momentum for constitutional change, and those of us who support it, how we should contribute, and this is what today's session is about, is trying to contribute to gathering that kind of momentum. But the other point that I want you to consider is looking back on the wording, because I first met with Brian Lenihan in November 2006, and that was prior to a general election in 2007. It was a very difficult time. It was a very tight timescale to try and reach the level of political consensus that would have been required to have a referendum in advance of a general election. It was absolutely clear at that time that the 2007, the 28th Amendment, did not enjoy political consensus. And really that was the starting point for this Oireachtas Committee's deliberations. I mentioned that it's taken over 2 years. Mary O'Rourke quite rightly and proudly presented that report in February. But what we haven't heard is an expression from government of its view on the recommendations of the Oireachtas Committee. And we haven't yet got clarity on the forthcoming referendum. It's been referred to by a number of ministers. Dermot Ahern referred to a referendum that would take place in the autumn. So it has had some passing reference, but not any formal view expressed by government at this point. I suppose another point that must be emphasised is that we should be aware, and I'm not suggesting for a moment that constitutional amendment is a panacea for children, but giving life to some of the principles enunciated in the proposed amendment will require a concerted effort. And I suppose perhaps I didn't fully appreciate this until I was in this job and I'm interfacing more regularly with public administration. But I'm talking specifically on the part of Oireachtas, government departments, the Health Service Executive, not just the judiciary. And I think probably if I were to encourage you to do anything today is to think beyond judicial processes, because day in, day out, there are many people, in fact more people, making decisions that have a profound effect on children's lives outside of a court environment. So what I'd like to do is just look at this through the lens of my own office, our own work. Dating back to 2007, we had Bertie Ahern's comment on the need for constitutional change, and acknowledging at that time that it was a first step in the development of a culture of respect for the rights of children. From my point of view, I suppose it is interesting watching what happens to our constitution in Ireland. I'm a member of the executive of the European Ombudsman, a group of 37 Ombudsmen across Council of Europe member states. And our constitution is not an abstract document. My experience is that it's not an abstract document as in other jurisdictions. And it's interesting to see, while it ends up being a legal document, how policy and politics drives whatever gets into a piece of legislation, and how important it is to recognise that. But I suppose on reflection over the 6 years, what I would say is what concerns me most is the breadth of the instances with which we see the same, or which we see a recurrence of the kind of problems, the kind of obstacles or barriers to genuinely considering the interests of children. Our own recommendations as an office, I mentioned, were rooted in the principles of the UN Convention on the Rights of the Child. But the vast majority, I mean, I've heard a lot of people talk about intervention and the possibility of opening up or encouraging a more interventionist approach by the state. Constantly, time and time again, the parents that come to us talk about inaction. It's about protracted inaction. It's not about intervention. It's about, we have a sick child, or we have a child with special needs, and we have not had help for years. So it's very much rooted in inaction and a lack of support for families. I'm just recalling, I don't really want to cite particular cases, but I am recalling a number of parents, in particular parents of children with multiple needs, and in families where there are children with more than one child with a problem, and where there's been a protracted period of inaction, and then when the family is in crisis, a completely disproportionate response from the state. And the fears that those families express is, I was able to parent my child 10 years ago. We were able as a family to cope and to manage. Through inaction, it's no longer that single problem for that child, but it becomes an entire family. And in fact, some of the parents will tell you that it pushes them to the extreme in terms of their own mental health. So yes, people will argue and say, well, it's going to be very costly to do what you're describing, which is early intervention and early support for families. I would argue that leaving families like that and waiting until they're reached such level of crisis is far more expensive, because you're not just supporting the child, you're now treating an entire family who's unwell. And the kind of questions that are asked then at that stage are about parenting and the ability of a family, ability of an individual or a couple to parent their child. Questions that should never need to be asked if those families were supported appropriately in the first place. So in the very early stages, back in 2006 actually, if you go back and look, there were 2 briefing papers that Brian Lenihan produced. And in the second briefing paper, he introduced the principle of a proportionate response by the state, which I suppose I feel very strongly about, because what I see is disproportionate response at the wrong time. It's too late. But a proportionate response keeps them at bay. It supports the UN Convention, it supports the Constitution's belief in the primacy of the family as the right environment to bring up a child without a desire, without, I suppose, opening the gates to unnecessary or unwanted state intervention. But I suppose in terms of proportionality, that's our experience, is a lack of intervention and a lack of support. In terms of participation, this is the one that children themselves raise with me most often. Children themselves attach a huge, I suppose, emphasis on being afforded an opportunity to speak. Some of the context that has happened in relates to family law courts, children in care in particular. Most of the children who come directly to the office are children in care. They're children without parents. The groups that we recently spoken to are separated children who were here without their parents, not of their own accord, and children in institutions like St. Patrick's Institution, where I would say at worst their right to participate is being ignored, and at best it is inconsistent. But when children talk about participating, I suppose this is the one that does get me into quite a bit of difficulty, especially if I'm talking in an education environment. People would say, it's okay for you there talking about children's rights, why don't you talk to them, why don't you start talking to them about their responsibilities? And talking about respect for adults towards children, that shared respect, very often you can see, in fact it's often palpable when you go to a school, if children are not treated very well. You can feel it. I'm not a teacher, I don't know anything about education, but you can actually feel the culture of an environment where children are not respected and not listened to. We're at the final stages of a consultation with young people in St. Patrick's Institution, and they will tell you that there's no point, waste of your time, telling anyone any of their concerns. A, they won't be believed, and B, they're not prepared for the ramifications that will ensue if they do say anything. Separated children, we had a group of 35 children who worked with us last summer. Shout at me if I'm going on. And they described being part of the asylum determination process, sometimes without a guardian, sometimes without an advocate, sitting in a room with a stranger and trying to convince that stranger at the age of about 13 or 14 that you're at risk of persecution and that they should not return you to your country of origin. In fact, a lot of those children described a feeling or a perception of being tricked, or an attempt to trick them into saying things that they shouldn't say. A very strong sense of not being believed. So the kind of things, while people looked at the Ryan report and said, oh, that's terrible, I'm hearing that all of the time from children in the context of child protection, in the context in particular of institutions, in the context of care. Children in care are saying adults are sitting around, you're having multidisciplinary teams where adults are sitting around making really important, sometimes decisions that will have a profound impact on a child's life. No involvement of that young person. So it's quite extraordinary. Now, I suppose I'm dealing with children perhaps, well, obviously that are on the margins, but it's very, very consistent. That repeated pattern of children not being listened to is still very much, very, very much there. So that's, I suppose, proportionality. That's the principle of children being heard or not being heard. The other principle that we, I suppose, are coming across quite commonly is that of discrimination, or non-discrimination as it's called in the UN Convention. And the differential of treatment, I know Rosemary's going to talk about adoption. In our case, again, I would cite separated children as another example of children who receive a different or discriminatory treatment of care. The care and support offered to these children is still not on a par with that afforded to Irish children in care. What we did was the health service executive even franchised out the care of these children to private companies without making sure that they were going to provide the kind of care and the standard of care, accredited care, that they would expect for Irish children in care. So there were 9 hospitals being run in the Dublin area. Since we started that report and worked, I suppose, made recommendations very immediately to the HSE to say you should stop this practice, that practice has ceased since September. But you certainly wouldn't get the same arrangement for Irish children in analogous circumstances. It just wouldn't happen. But you don't have parents and you don't have anyone shouting and standing up for these children. And you certainly, they're, I suppose, invisible in terms of the public consciousness. In terms of the final principle of best interests, we recommend the inclusion in the Constitution of a provision stating that in all actions that the best interests of child shall be a primary consideration. And while it's about incorporating the essence of Article 3, we of course have always had debates, and I'm sure we will have today, about determinacy. Has always been the big issue about best interests. How and who will determine what's in the best interests of a child? We have been looking, I suppose, in the main at local authorities, at the Health Service Executive, at the Department of Education, and we did an investigation just to give you an idea of the kind of things that are coming up. In 2007 we published an investigation into an application for housing made by a child's mother on the basis of a severe disability. In summary, our findings indicated that this child, who was 12 years old, had an inactive file for 4 of his 12 years of his life, with his disability becoming progressively worse. And what we found was that the local authority, I suppose our findings were that the local authority hadn't considered the best interests of the child when processing the application made. And of course this child was adversely affected by the actions of the public body, but when we went to review the policies and we went to review the legislation that underpins the decision making, you find that there's absolutely no guidance for people in local authorities to say, have you considered, do you know that you have to consider the best interests of children? In fact, the conversation I had with the local authority was very simple. The person said to me, my job is about bricks and mortar. It's not about thinking about where this child goes to school, where the family support is. My job is to provide the building. And when we talked to them about the idea or the notion of talking or engaging with the child's family and himself in order to have a better understanding of what might be a better home for that family, they thought we were absolutely daft. When we talked to the child, what was very interesting, they were apprehensive about asking the family because they thought they'd be asking for a 5-bedroom house with a big garden. And when we talked to the child talked about respect, he talked about dignity, he talked about independence, he talked about privacy. He never referred at all to the building. And we would hear that very commonly: dignity, respect. They're the same kind of principles that come up all of the time. So I suppose for us, the recurrent themes, if you like, is best interests, a lack of consideration of best interests, lack of consideration of participation of children's views, non-discrimination principle. So I would finally just say to you to think beyond your own comfort zone, and whether that's in a judicial context, think beyond that, because there are civil servants, there are public administration, there's Oireachtas, there are legislators, policy makers who are making decisions all of the time, and some of those decisions will never ever reach a court. So it's beyond the court, it's beyond litigation, the notion that the Constitution could have a long-term effect for children. For us, it's not just about the short-term litigation, but it's more a long-term changing the mental habits, if you like, of public administration, and getting people to think very differently about how they make decisions, and to make sure that Institutional loyalties, we saw in the Ryan report, making sure that children's interests are placed ahead of institutional loyalties. That hasn't completely gone yet. We still have that, where people are put under pressure to make sure that they represent their organisation appropriately, and children's interests get lost in that mix. I think I should probably stop there. I think I've probably gone way over, I'm sorry. You're welcome to go onto our website or contact any of us. I should have said that Monas is with me, who's our very able Human Rights and Policy Officer in the office, so he's always good for a chat too. Thank you very much for the opportunity, and I look forward to hearing what Conor and Rosemary have to say. Thanks.